Hey guys, welcome to this video. I'm going to start a new series where we go through the actual violations of the FDCPA. So we've done a series where we go over the text of the FDCPA, the Fair Debt Collection Practices Act. But I want to go through some common violations and not just tell you that these are violations, but show you from the text of the FDCPA itself that these are violations. So the first one we'll start with is what is known as third-party contacts. And there's really two types here. One is where they are obtaining, quote, location information, end quote, illegally. And the other is where they're contacting third parties and they're not even trying to obtain location information. So let's start off with section 1692B. And this tells us that a debt collector is communicating with any person other than the consumer. Well, why are they doing that? For the purpose of acquiring location information, and we'll look at the next slide, will tell us what that means. About the consumer shall, so this is not a suggestion, it's not a guideline, this is the absolute requirement of the law. The debt collector identify himself, state he's confirming or correcting location information concerning the consumer. Number two, not state such consumer owes any debt. And then number three, not communicate with any such person more than once unless requested to do so, or unless the debt collector reasonably believes the first answer was wrong or incomplete. So now we have to say, well, what is location information? Because remember, this whole section is dealing with obtaining location information. So we go to our definition, 1692A, and then this is subsection 7. Term location information means three things. Consumer's place of abode, in other words, where do you live, your home address. Telephone number at such place. So notice that's not cell phone, that's your phone number at your home address. Then number three, place of employment. So it's not asking, we're not saying that this means what's your salary, how long have you worked there. It's these three things and only these three things. Place of abode, telephone number, where you live, and place of employment. Well, let's look at 1692C. And this is just talking in general with communication with third parties. It says, except as provided in 1692B. Well, that's what we just looked at, is obtaining location information. So if we're not obtaining location information, this is the statute that we look at. Without the prior consent of the consumer given directly to the debt collector. Now, debt collector calls you, you say, hey, speak with my mother, speak with my boss, speak with my second cousin 3 times removed. Well, then it's okay. So they can't talk to anybody unless prior consent given directly to the debt collector. And then it tells us the debt collector may not communicate with any person other than the consumer, his attorney, a consumer reporting agency, that would be Equifax, Experian, TransUnion, if otherwise permitted by law, the creditor. So the debt collector is collecting on Discover Card. Well, they can communicate with the creditor. That's how they would, quote, verify the debt. The attorney of the creditor or the attorney of the debt collector. Well, what does consumer mean? Because this is talking about may not communicate with any person other than the consumer, his attorney. Well, what does the consumer mean? For purpose of this section, it's not talking about any other section, this section, consumer, includes the consumer's spouse. It also includes the consumer's parent, but only if the consumer is a minor. So if you're 21 years old and they're calling your mom or your dad, that is not fitting with this section. That would be a violation. And then it goes on guardian, executor, administrator. In other words, if somebody maybe is incompetent and a guardian has been appointed, or they passed away and now we have an executor because there was a will, or an administrator because there was no will, then that would be allowable. So what are the conclusions? If the debt collector is legitimately calling to get location information, they've got to be very, very careful that they don't reveal the debt. They don't ask for anything other than location information. Remember, that's address, home phone, place of employment. And they can't call the third party more than once unless there's some reasonable belief third party was wrong or has more information. And if they're not trying to get location information, that's absolutely illegal to contact anyone other than the spouse or the lawyer. So a debt collector calls a third party and says, hey, I'm trying to verify location information. Can you tell me where John Watts works? And my neighbor says, sure, here's where he works. Well, how long has he been working there? Nope, that would be illegal. Or can you give me his email address? I need to send him an email. That would be illegal. Or, John owes this debt. Or they imply, they say, I really need to hear from John because there's something he needs to get to me and he's late on. I'm not allowed to tell you what that is. See, that would be suggesting that I owe a debt. Well, what if they just call my neighbor and they say, hey, I'm trying to get John to call me back. Will you go put a note on his door? Well, see, that's not getting location information. And that's, unless I gave permission to call my neighbor, they can't do that. And all that's in the context of trying to collect a debt. So this is a favorite violation by the debt collectors. And here's the reason why. It absolutely works. I mean, they start calling your neighbor, they call your mom, your ex-father-in-law, your ex-sister-in-law, your cousin 2 states away. Man, that gets your attention because those people call you and you're like, oh my goodness, I can't believe they're calling my family, they're calling my neighbors, they're calling my boss. It'll make you pay the money. Now, it may be effective, but it's absolutely illegal. We've talked about this in other videos. If they kicked open your door and shot you in the knee with a shotgun, that would be very, very effective. I mean, that would get money paid like crazy. And if we start hearing about, portfolio recovery or Midland funding, they'll come and shoot you in the leg. You better believe people pay them. It's absolutely illegal to go. Same thing with these third-party disclosures. So, 4 requirements for the FDCPA to apply. You have to be a consumer. In other words, you're not a partnership, an LLC, and there are some slight exceptions to that, but just general rule, you got to be a human being. Number 2, consumer debt. So we're not talking about business debt here, and there's some other types, but basically what we're talking about is consumer debt. Credit card, medical bill, your house payment, the things that you use not for work or for a business. The person calling you has to be a debt collector. That company has to be a debt collector, not the original creditor. And we have other videos where we go into detail about what is a debt collector. And then it has to be a violation of the FDCPA. It has to be harassing, it has to be lying, it has to be unfair in some way. Well, if you sue, what can you get? You can get actual or compensatory damages. So that is to compensate you. So let's imagine that on a scale of 1 to 10, right before the debt collector broke the law, you were an 8. But then that knocks you down to a 5. Maybe you lose your job, so you have economic loss. Maybe there's mental anguish involved. You're just very upset by this. So we say, well, what will it take to bring you back to where you were right before that debt collector broke the law? That's to compensate you. You can get statutory damages. Even if you have no actual damages, that can be up to $1,000. Your attorney can be paid by the debt collector, so you're not having to pay attorney's fees. The cost of litigation, so it costs $400 or so to file the case. Depositions may be taken, all sorts of expenses. Well, the debt collector can be forced to pay that so that you're not having to pay that. And then if you have a state law that allows this, such as invasion of privacy, you can get punitive damages against that debt collector to punish the debt collector, to deter the debt collector and all other debt collectors from doing the same thing. In other words, from making illegal third-party contacts. So that when somebody's thinking about it, they go, wait a minute, I remember that big punitive damage verdict in Alabama when Midland Funding did this, or Midland Credit Management did this, or LVNV, or whoever it might be. You know what? We're not going to do that. That's the purpose of punitive damages. So if you have any questions or comments, you can put those below, or you can get in touch with me directly, 205-879-2447 or alabamaconsumer.com. Appreciate you watching this video, and I will catch you in the next one. Bye-bye.